Hello, hello, everybody. Hi, Jonathan. Hadn't seen you in a few weeks. I don't see you now, but I see your name. There you are.
Hey Saber, how are you?
Good, good. How you doing?
I'm doing well. I'm trying to find a pencil.
Well, I'm gonna try to find some forms.
Yeah, I hear you. I got them here.
Oh, good.
So
I
we're good
tell
to
you
go.
what, I went flying to the grocery store a few minutes ago to pick up a couple of things, and all of a sudden I looked down at my watch and I went, "Oh no, I got to be at the house at 1 o'clock." So I left my buggy with groceries in it.
Oh my gosh.
Took
Here, here's
off. So I
here's
thought, oh no, I got to be able to get home by 1 o'clock. I don't know. I don't know. Well, I do know where the time went. I was on the phone talking to an agent.
oh, that's too funny.
Oh,
Yeah, about
but
an hour ago, I looked over at one of the clocks in the room and it still wasn't set to the new time. And I'm looking, I'm just watching the Zoom scroll around and I'm like,
yeah.
wow, we're running late here.
Oh,
So
I
you
know.
are
I'm not. I haven't acclimated yet to the new time. I generally don't have any problem with an extra hour. But if your clock is already somehow in my mind, I was thinking I still had an hour, and I
yeah.
go, oh no. So I guess that poor little fellow that saw me tear out of that grocery store was going to be upset with me for leaving a buggy of groceries. But I'll have to go
Oh,
later.
that's funny. That is too funny.
Oh, good, good. You got a buyer going on right now?
I got a few in the works that between now and April, so
Oh, good,
we'll see
good,
how that works
good.
out.
Oh, good. Okay. Well, we will see if I can find some buyer forms today. The
That sounds great.
oh, and I'll try not to lose you. My famous saying, I try not to lose you. It just amazes me every time it's so different. It's like, why in the world can I not get the pattern here? But nevertheless, let's see what I can do.
No, you do great. So I'm looking forward to it.
Thank you. All righty, let's see. I've got to find my forms. There we go. North Carolina buyer consultation and buyer forms. Aha. Okay, now let's make sure I share them with you. And we might be in business. That would be a nice thing. Aha! I'm beginning to get the pattern. I got forms and I can see your face. So that means you must be able to see my forms, correct?
I can see your forms. They look good.
All right. All right. Let's get started there. Get on up here. When we start working with buyers, we always recommend that you have a buyer consultation. It sets the pattern for the whole relationship. You know, if you can take the leadership and say, we really need to sit down, we need to look at some things, let me find out what you're really looking for, position it where it's about them and you listening to them. You've heard through the years, I'm sure, as salespeople, we like to talk, and yet the more we listen, the more we sell, because then we hear and know what's going on in that client's mind, and then we're going to try to figure out what the next step for us is. So you really want them to know you're listening to them. And the way you do that is hopefully to get them to come into the office or another setting where you can sit down and go over a buyer's questionnaire with them. And we have a lot of questionnaires. We have, Ignite has one. We have one from what we used to have, Camp 443. We different agents have designed them. This was just seems to be the simplest one. And mostly I wanted to put this in there just for you all to know the questions to ask. I don't care which order you ask them in. I don't care if you put it on a form. Again, this is for you to have a little record and know where you're going in this buyer's question with the buyer's questionnaire. You know the questions to ask, things that you're going to need to know. Of course, as we get into the forms from North Carolina Realtors Association, you'll have a lot of questions as well. This, like I said, this is just a very simple one. Just kind of breeze through it. I'm not going to go through it. I just want to stress the importance of you taking the time to sit with your client and go through some details. Now, I know the client just wants to see the house. They said, forget all this stuff. I just want to see the house. Well, if you can't get them to sit down, at least know these questions to ask them, okay? All right, so, and if you want some other styles of questionnaires, let me know. One very simple thing is one of the agents often use is, tell me the top 5 things that you're looking for when you're looking to buy your house. And they just write down those 5 things. They may change and they may be different as you progress, but start with listening to those at least 5 things. And then when you get the contract, you want to send them a little note and say, how did we do? Did we get 4 out of 5 or did we 5? It's just another way that some buyer's agents again, show the client they're listening and see how well they do. Obviously, the very first thing you want to do, other than talking to them about the buyer questionnaire, is this is something that legally, you have to present to everybody that you talk to. And the technical term is on first substantial contact. The first substantial contact. Substantial means, are you having a conversation other than it's been nice weather lately? Or do you think the hurricane's going to get us this week or whatever? A substantial would be, what is the motivation? What type of financing are you looking at? Have you sold a house before? Some of those questions that start digging a little deeper than the surface, then you want to stop right there and start talking to them about how we as realtors in North Carolina work with clients, whether they're buyers or sellers. But in this situation, as we're talking about buyers, and sometimes when I may have showed you all this before, but when you're in an open house and somebody comes in and they immediately start just pouring out information and you're going, I'm not supposed to hear this. I'm not supposed to hear this. At that point, put your little hand up, just like the school guard, cross guard, and say, no, I got to talk to you first. I got to tell you something before we go into those details. It stops the conversation. You take the leadership at that point and say, let's sit down and talk about this. I need to give you a disclosure. By law in North Carolina, I have to disclose this to you. This disclosure is not something that is disclosed from the seller or buyer themselves. Obviously, it is only your disclosure. You as a realtor affiliated with Keller Williams Valentine will be able to offer them the service in all 3 areas that are listed on this form. Some firms do not offer all 3. So this is the way we realtors in North Carolina work as a result of working with Keller Williams Valentine. The thing that you want to stress the most is this form is not a contract. It's only a disclosure. It's just something I have to make you aware of before we go too much deeper. It's not a contract, and it only means I'm going to ask you for your signature that I gave it to you. And that's the legality of it. Now, the 3 things you want to disclose to them is that we can work with them in a relationship called a buyer's agency. Okay, that's sometimes referred to as single agency. Single agency is when you represent one agent representing one party, whether it's one party on the selling side or one party on the buying side. So in single agency, it's very clear cut, very simple. One agent representing one party. And that is what we would call buyer's agency if they choose to work with you in that way. The dual agency basically is one firm representing. It could be the firm representing the seller and the buyer on a single transaction. It can also mean the firm being what we would call the dual agent And it may be that the firm can designate another agent to represent one party. So if you, as the buyer's agent, show a property that's a listing of Keller Williams Valentine, and you write an offer on it, you are still representing the buyer, and the listing agent would be representing the seller, but there's one firm. The mutual firm is Keller Williams Valentine, correct? In that scenario, one of you would be designated to represent the buyer, and the other would be designated by the firm to represent the seller, because you are already in those agency relationships. Sometimes you might have a scenario that you would have to, maybe you're the listing agent and you have a buyer come in. You might have to have someone designated to represent the buyer. So there are different styles of designating, but make sure that the buyer understands that he is not automatically in a dual agency situation unless he chooses to allow an individual dual agents. You don't want to go into too much detail, because we're going to go into detail in a few minutes with the agency agreement. But right now, just to tell them there are ways for them to be represented, even in dual agency. Now, this little section here, unless you are working with, or you're trying to work with a buyer who decides they want to work with you. You know, maybe the buyer decides they're going to represent themselves. And there are some buyers who do that. They decide that they will represent themselves. And if that's the case in our state, if they choose to do that, you are just going to give them a little notice that they must not disclose too much information to the seller, because the seller then, or a listing agent, would be able to use that against them. So you basically are going to tell them that you're not going to represent them in that situation, because you would be what would be called a sub-agent of the seller, and you can't be with most firms. So just warn them of that. Now, this is the form that came into being just last year, actually. It's a one-pager. There is a really good little pamphlet or brochure, and it's by the same name, working with real estate agents. And that is a little brochure that if they have more questions about agency, I would suggest you having some of those brochures on hand, or you do have it available in your forms program. So you might want to send that brochure because it's in the form of questions and answers. It used to be what we had to explain, and we're really happy to have a one-pager now on this disclosure form. Again, here's where you have the buyer's signature. You want to put your name, your license number, and the firm name here, and offer them the brochure if they would choose to have it. They can actually get it themselves from the North Carolina Real Estate Commission, but you can offer it and send it to them. Now, I like to have, and again, maybe I'm different than some folks. I guess I'm pretty visual, you know, and I like to have an overview of the contract. I like drones. You like the pictures of the drones where you look at the neighborhood and you see the whole neighborhood, where the pool is in relation to the house. I like overviews. So this is an overview of our offer to purchase. This is something you can give to a buyer if you choose to. I'm more concerned that you have a grasp of the contract, the offer to purchase. So I'm going to talk through this just a bit to kind of give you the overview again, but you can have this as something to refer to when as you're thinking what's the next step in the process. We have it divided out actually in 3 phases. The contract is when you're starting to work with your buyer. Your first phase, of course, is going to be after you have that consultation. You want to make sure that they are connected to a lender. They may already be talking with a lender before they ever connect with you, or you definitely want to connect them with a lender or lenders for them to make a choice of a lender and loan product, because when you make an offer for them, you want to be able to have what's called a pre-qualification letter. We prefer it being a pre-approval letter. Some lenders will not give you a pre-approval because that means they've taken extra measures of running some reports on them. But if you have a lender at least pre-qualify them, they will give you a letter that you can give to the seller along with your offer to purchase as you're trying to get it accepted by the seller. One of the things you want to do is that's like parallel. While you are working with them to try to identify a house, you want them also working with lenders to determine the lender and the loan product. So it's kind of a parallel scenario at that particular time in phase one. And as you find that house, then you're going to be writing an offer to purchase. And in that offer to purchase, there's some decisions that are going to have to be made. They're going to have to decide on the length of time for the due diligence. They need to decide on the amount of money that they're going to pay for that amount of time. And that would be paid directly to the seller. And then there's earnest money, which is going to be paid to an escrow agent. Typically, it's the one that's being chosen as the listing agent. So these are steps on phase one. And obviously right here, it denotes that you were going to give them work with real estate agents that we just talked about. You're going to have the consultation and find out their 5 things or whatever the answers to the questions are. And then you're going to help them to understand the buying process. Again, this is the buying process that we're talking about right now. Then when you go into your offer to purchase, once that's written, you go into phase 2. That's actually the beginning of due diligence. That's where the buyer is going to have the right to inspect the property, find out anything about CCRs, find out anything about mold, all of these things that are itemized. All of these things are also itemized in your offer to purchase. It's in black and white in the offer to purchase that the buyer will and seller will sign. But again, this is your overview in one page of what's going to happen. After they have gone through the period of, or during the period of due diligence, they've done all this. Once they have determined whether or not they're going to move forward or if they're going to terminate, it will most likely be based upon this right here. What happens as you negotiate repairs? The repair negotiation is done on a form called due diligence request. That form is one thing that you want to prepare pretty quickly after getting your inspections done so that you can get it in the hands of the seller. Then the seller can do their due diligence on what it's going to take to respond to the buyer, because everything has to be done. All the responses have to be done during that period of time that we call due diligence period. The end date of the due diligence period is in the contract, so you know exactly what period of time you're looking at. And again, we're gonna go line by line to that in just a moment. Now, when you get through the due diligence period, this is where you're going into phase 3. When you go past the due diligence end date, the seller should feel pretty confident at that time that that buyer is going on to closing. There is no out for the seller. There is really not an out for the buyer unless they're willing to lose the due diligence fee, because it's been paid to the seller and they're going to lose it. But on the earnest money, there could possibly be some outs, as we'll say, and we'll talk about that as we go through the offer to purchase. One of the things you need to be aware of in the North Carolina, excuse me, there's a difference in settlement and closing. It's taken me 30 years to learn to call settlement day instead of closing day, and I still say closing day. Closing is not done at the attorney's table. When the buyer and the seller go to the attorney and sign all these papers, that's what's called settlement. That's the settlement date. The buyer turns over their money, they turn over their down payment, and sometimes it's wired in to the attorneys, or if they bring in a certified check, it has to, it is brought in at that time. They sign all the papers. Then from that point until the deed is recorded, it's in a processing mode from the attorney. There is another title search done, one last title search before the deed is recorded. The authorization from the lender is given and the money is released. The the attorney for the settlement then records the deed, and when the deed is recorded, that's when the ownership is transferred, and you can say the property has been closed. Okay, the four things: the settlement, where the papers are signed, the release of funds from the lender, the final title search by the attorney, and the recording of the deed. Then you say the property is closed. And at that point, there's a distribution of checks. The agents get paid and the seller gets paid, and keys are distributed at that time. More and more, we're seeing keys not given at the closing table. Settlement table. There I go again. And we make sure that your buyer understands that they might not get the keys, and most likely will not, and then you verify it with the listing agent. Okay. Now, this little section right here, if either party fails to complete the settlement closing within 7 days of the original settlement date or negotiated extension, the responsible party is in breach if they delay past 7 days. Again, we're going to go through it a little bit more detail as we go through the offer purchase. So that is a very broad overview with some specifics in different aspects. So now you've seen an overview, and you're welcome to learn this yourself. Now, this little form is also a form that you may want to use. It clearly explains the process of the due diligence fee. See, the due diligence fee is for a period of time within the broader period of time for closing. This is where you start your contract over here. This is where your effective date. Then you're going to have a period of time known as the due diligence period that the buyer pays a fee to the seller. And during that period of time, the right that the buyer is buying is to have the right to terminate the contract for any or no reason at all. It's about the contract. It's not about all those steps of due diligence, although they have all those steps of due diligence allowed to be done. The right is to terminate the contract. The money stays in the hands of the seller. The DDF does not go back to the buyer. Whether if he terminates, that's the one of the penalties, I guess, of terminating, but he has the right to terminate. Now, once that is paid, you see here that here's the note here. If a buyer walks during this period, they lose the DDF, but the seller can't come back and sue him for anything else. They can't come back and sue for specific performance, which you hear a lot of. Basically, it's the buyer's right to terminate if they find a reason or if they just change their mind. Okay, this ends on 5 p.m. on whatever date that's listed in the contract. It lists at 5 p.m. Now, the earnest money is a separate amount of money. It's also paid up front. It's paid within 5 days of the effective date. DDF is paid on the effective date of the contract. the earnest money is paid within 5 days, and that amount of money is held in escrow by the closing attorney. The due diligence fee and earnest money will be credited to the buyer's closing cost. So if this contract is not terminated right here, the buyer will see a credit of that due diligence fee on his closing statement, just like he's going to see the earnest money on the closing statement, so they get credit. One of our agents said they tell the buyers right up front, kiss this money goodbye, unless you see it credited on that the closing statement when you go to closing, because the DDF, the intent of the DDF is that the seller does keep that money, and it's only on paper that it's credited back to them at closing. This again is just an overview. If they're having a little difficulty understanding what due diligence fee is, it's not something that all states do. There are a lot of states who have some form of due diligence. They have inspection periods and they have fees involved, but our North Carolina contract is not the norm. Okay, so sometimes it helps to actually have something in a visual like this to explain it further than just your words. Okay, those are two things I'll send over to y'all. If you want to put your email address in the chat box, I'll email all of this to you after the class. Okay. All right. Now here's your buyer's agency agreement. Your buyer's agency agreement is your employment agreement. Let me enlarge that a little bit for you. You want to be able to have a buyer's agency agreement with everybody you work with. Sometimes people are reluctant to go into a contract with you until they know you better. All right. So if you want to take the risk and work with someone on a verbal in North Carolina, you can proceed forward on an oral agreement. I wouldn't go too long on an oral agreement. In fact, they actually, the form writers actually recommend that you put it in some form of writing, like an email, or there is a letter you could use. But I believe this has worked for me. I mean, this is just me personally. There's sometimes I don't know if I want to work with them either, so for me to work with someone one day, I'll give them a half a day and I'll show them 6 or 8 properties without having it in a written form. But when I normally tell them, when we get, we're going to go back out and look for these houses, and when we get back to the office, that's when you and I have to decide if you want to work with me, and I have to decide if I want to work with you. And then I laugh, but I'm dead serious, because there are some people that you can tell right up front, y'all are not going to work well together. So don't feel that you have to work with everybody that comes across your path. I know right now, as you're new, you're thinking, yeah, I do. I want to work with everybody. But somewhere along the way, you'll realize that there's some people that are just not worth it. You can have 2 or 3 other buyers for that one buyer that you might let go. So, or refer them to your best friend. Get a referral fee. Okay, back to the buyer agency. This is Form 201. And if you see Form 201G, there are guidelines in your forms program. If you want to look at those, they're available to you. Now make sure that you want to look and see on okay, come on down here. You want to see the date, the copyright date. We are using Form 201, and the copyright date is 7/2022. Obviously, that was it was copyrighted in July. The forms in North Carolina are changed, at least some of them, every year in July. It's very systematic. Every July 1, we have new forms or some change to forms in North Carolina. So you would see a copyright date of 7/2022 on almost every one of the, I think it's 70 or 80 different forms that we have. Just make sure you have a current form. You have a little grace period of July and August, but this time of the year, make sure you have the correct form in place. Now, let's talk about the buyer's agency agreement. Obviously, your date is the date you're filling this out, the buyer's name. You do not have to use the legal name, but I would suggest that it's best that you do. Some agents ask for a driver's license if they're in person, just to get the spelling of the person's name so that you actually have the people that are talking to you, that you have the right spelling of their name. Now, and right here, this line is for the firm name. It would be Keller Williams Ballantyne area, and you don't have to put Jonathan Jacobs. You are a sub-agent. You do not have to put your name. This is agency agreements are with the agency, with the firm. All right, so this would be the buyer's name, and this would be the firm name. Now, as I look at this paragraph, look at this little thing right here. Anything that's written in a blue is a note. It's a suggestion, something for you to think about, be aware of. If it's a red box, it's a warning. So and you better be aware of it. Okay. In this situation, there are times that this buyer might be something or somebody other than an individual person. You might have a liability company, LLC. You might have a corporation, a trust, or other legal entity, and make sure that you name the buyer as the entity if that's the case. All right. And you also need to make sure that that person has the legal right to bind that entity into this contract. This is a contract. It's called agreement, but it is a contract, legally binding contract. So if there's an LLC that's going to be purchasing something, a lot of investors obviously work on the LLCs. So you would have an LLC, the name of the LLC, and the word buy, BY, and an individual's name like John Smith, comma, manager or member manager. Most of the time on an LLC, it's going to be a manager. What you want to ask the buyer in that case is that you want to ask them to provide something in writing, and it should be in their LLC papers, who is the authorized person who can sign on behalf of the LLC. Typically, the name is manager. It might be registered agent, but just see if they can provide something. If they cannot, you want to go to the website SOSNC, the initials, SOS, Secretary of State of North Carolina, SOSNC. And you want to look up the name of the LLC, and you can determine by looking at their annual reports who it is who has the right to sign. And when you're asking for it, so the attorney is going to need it. So if you would, we need it, but more, it's going to have to be produced somewhere along the way for us to give it to the attorney. So that's just a little note that you need to be aware of. If they cannot produce that, or if they don't have the authority, then you're wasting your time. And you're definitely, or I should say, I started saying you're wasting their time. No, they're wasting your time. So you do need to clarify that. Now, this right here, I tell you what, when I'm doing this in person, I always come over here and put a little line right here to get initials that I've talked to them about this paragraph right here. I cannot tell you how many times a buyer will want to see a property and will want to work with me or one of our agents, and they're in an agreement with somebody else. You do not want to get in the middle of an agreement with another firm. The agent, the buyer, excuse me, the person almost always thinks that because they just stopped working with that other agent, that they're not in contract with them. It all depends on when that contract ends. And what you want to listen for is, if you might want to say, have you been looking, have you been working with another agent? And they may say, well, yeah, we saw some houses. In fact, we put a couple of offers in, and that none of them went through. So we stopped working together. a red light should have gone off in your head when you heard me say that, or you hear them say that. If they did place other offers, they would have had to have an agency agreement with one or more agents, okay? So that red light says to you, do you know when that agency agreement, the buyer's agency agreement ends? And they're gonna innocently say, well, we didn't get the house, so you know, they think it ended because they didn't get the house. You want to make sure that it is ended, because if you then put them under contract, you're obligating them to 2 real estate commissions. This agreement says that if they have working with, no matter who sells them the house, the person who has this agreement has the right to be paid a commission. And it normally doesn't come out quite like that, but that's what the words say. So you don't want to obligate them to do commission. So you want to make sure that they understand that that has to be terminated with the other firm, or it has to have expired before you work with them. Otherwise, again, it could cost them extra money, and it could cost you money because the other firm is going to expect you to give them some money for it. Now, that's why I generally want that little line there and initials there, because I want to have proof that I talked to them about it. It wasn't something that I just boiled over and made sure that they worked with me. The type of property right here is what you're going to want is residential. All right. We do not allow or do not recommend our residential agents doing commercial, especially as they're just beginning to work in the business. Commercial is a total different entity, and it can get you into trouble real quick. So I do not want to see anything but residential right here. General location, be very general. Do not say Pineville, Matthews, South Charlotte. If you put that specific and someone then decides they want to go to Statesville or Concord, then you don't have an agency agreement with them to go in those other areas. So if you would want to, what I would recommend you put is Mecklenburg County and surrounding counties. Therefore, no matter where you go around Mecklenburg County, you have the right to go and to get paid for in that area. If you are also South Carolina licensed, I don't think most of you may not be at this point. If you're South Carolina licensed, you also can put including Lancaster and York counties, South Carolina. But that only lets you go across the line and show a property. That doesn't let you actually work a transaction. But the main thing I want you to remember is put Mecklenburg County and surrounding counties. All right. Now, a term of the agreement, an agreement is not valid unless it has a beginning and an end date. So you got to have a beginning date and an end date. Now it says here, the term of this agreement shall begin on such and such a date and shall terminate as follows. This date most likely should be the date that you're actually executing it. Why would you have a different date? Typically, it's going to be the date that you obviously put it into action for showing them properties. Now, this is kind of new. I think it was not this past July, but July a year ago. Previous to this, a buyer's agency agreement basically was for one property. You work with the buyer when they purchase that property and close on it. Your agency agreement ends with the closing. Then you don't have any responsibility or any right to go further and show them a second or third or fourth property. Well, this works with most buyers that you're going to work with, but there are so many investors now that, and sometimes it's your buyer that have a primary residence, and then they decided they want to get another property, and you need to get another buyer's agency agreement, because if you've only checked this right here, that is for one transaction, or it may terminate during that or expire during that time, and then you can't work with them. Okay, so that is typically for a single purchase. This would be for buyers, like an investor or someone who wants to buy multiple properties. Then you would put a different date. In this one, you may want to put a date out, maybe 3 months, 4 months, whatever, for that one single property. This one, I would most likely go for a year, because if they're going to buy multiple properties, give yourself plenty of time to buy a number of properties. Now, the compensation of the firm, this is has become much more of an issue than it has been up until this past year, quite honestly. Oh, come on. Can't get it to go down. Stop. There it is. We do not use non-refundable retainer fees, so that's always going to be an NA. In here, this is the firm's expected commission. Until about in the last few months or a year, it was very rare that you ever saw anything but 3% in there, because the more or less acceptable commission in our marketplace was 6% for the seller to pay the listing agent and a cooperating broker, which would be the buyer's agent. Now we are seeing all measures of percentages in there. It may or may not be 6%. It may, and really for a period of time, we were seeing 7 and 8. It wasn't just 6. 6 was probably what we saw more, but we could see 7 or 8. Now we do not see it at that high, at that rate, from the seller side. So what we as buyers agents are seeing in our MLS, when it says a buyer agent percentage, BA, down at the bottom of your MLS sheet, you probably are seeing 2.5 more than you're seeing anything. You may also see 1.5, 1.75. You might see 2. There are a number of percentages offered, and that gets smart. In fact, some of the builders will offer a dollar amount. Agents, I'm not seeing offer a dollar amount, but the builders like Ryan Homes was the one. It's been the primary one. They would offer $4,000. It didn't matter what the price of the house was. It doesn't, it was going to be $4,000 to the buyers. And if the buyer's agent was representing an investor, it's $1,500. So, I mean, that's smart when you're anticipating a percentage of a nice sale to get $4,000. But that's what Ryan Homes chose to do. And it's up to the seller to decide how much they're going to pay a buyer's agent. And in that case, you might want to point out to the buyer that whatever percentage we put in here, it's almost, it should be a percentage other than working with Ryan. Some of the other builders did it for a brief period of time, but I don't think they have followed through on it like Ryan has. We are going to seek our commission from MLS, obviously. The MLS is our first line of having a guarantee of being paid. You want to look at the MLS, what they're offering, but every now and then, as I just explained, in our environment right now, we're not seeing what we anticipate getting paid. And if for whatever reason we can't get it from the MLS, then we have the right to go back to the buyer and ask the buyer to make up the difference. If the MLS is offering 1.75 and you come up here and get the, if you agree for the buyer to only pay you 2.5%, then, or 3%, then you would have the right to go back to that buyer and ask them to pay that additional 1%. Because obviously you're in business to make a living. You're in business, this is not a hobby. This is the way you're feeding your family. This is the way you got to pay Uncle Sam. And, you know, you do have to share some commission with the firm that you're with. So therefore, when you start thinking of the amount of money that you need to make out of each sale, depending on the time and the energy and the experience that you put into it, you have a right to be paid an equitable amount of money. All right. It doesn't mean that you can't accept the 1.75, but at the same token, this contract allows you to go back to the buyer and ask him for the difference. That's probably more explanation you need to give to the buyer, but I want you to be comfortable and understand what happens when you put 2.5 or 3. You have the right to ask the buyer for it. Now, in this little section here, it basically is helping the buyer again understand that you're going to have a right to ask for payment. What I see more on this one is using the form 220. 220 is a form that, let's say you're going to sell a property maybe in Hickory, and we don't have their listing in MLS. And so if you want to get paid, you need to do form 220 to go with the offer to purchase, so that seller and that listing firm, if they sign it, they agree to pay you that amount of money. Sometimes we also would use 220 if there is a difference in what is in the MLS, and we want to ask the firm for an additional amount. Let's say it's offered the 1.75, and we want to ask that firm, would they consider paying 250? Excuse me, 2.5. If they would do that, then you would use that same form 220. And I heard that many of the agents, when they asked for the increase, depending on if the offer is a good offer, then sometimes that agent themselves, or that firm, the listing firm, will agree to pay more. So that 220 is a good form for you to be familiar with. Now, in this one right here, we haven't seen this very much lately, but I would imagine the next few months we might begin to see it more. Let's say that you had 2.5 in here, and you sold a new construction, and they are going to give 3% instead of 2.5%. Well, then you are required to give a form. It's form number 770. You are required to let the buyer know that you are getting that extra 0.5%. And I have to be upfront. Anytime they think you're going to get extra money, they think it should go to them, that it should not go to the agent. So just be prepared that if they indeed expect you to pay them that 0.5%, remind them that commission is paid to the agents. Agents do not have to share it. But a long time ago, I made a business decision that anytime that I got a bonus or an incentive, I would split it with my buyer. And so I tell them that up front, so that they understand they're not getting all of it, but I am going to give them half of it. That's my business decision. So you might have to make your own business decision, but help them to understand that that's the way you work. Now over here, that there's that form number I just told you, 770. Now this little section here, this basically is what's called a protection period. If for whatever reason this agency agreement expires, or if you terminate it for some reason, you still have a protection period of whatever number of days you put in here. You can put 60 days, 90 days, or 15 days. I wouldn't put 15 days because anybody can wait 15 days to go back and try to buy us for sell by owner, but they might not be willing to wait 90 days. So I typically put 90 days. It's totally up to you on the number of days, but that's what's called a protection period. That if for whatever reason that buyer is able to negotiate the contract on their own, then you would still be due a commission. All right. And again, a buyer, if you've terminated or is expired, the buyer would have the right at that point to go ahead and sign with another agent, and there would not be any commission due. All right, based upon this term. Let's say down here, the firm's duties, they've outlined these. You remember fiduciary duties? You remember that term? Every time I say fiduciary duties, I am reminding one of our longtime idols in real estate in this area who love to use the word fiduciary. But you want to use that term so they recognize it's something unique, to real estate. They have, the form writers have outlined it quite well here in simple terms. The general, the confidentiality, the standard of care, representation of others, and submission of information to the listing service. You remember the acronym OLD CAR? That's what you learned in pre-licensing school. Those are your fiduciary duties. And again, the form writers just put them in simple terms here. The disclosure of buyer's name and mailing address. This is where it's giving you the right to disclose them and when it's needed. Now, right here, this is something relatively new that it again was put in not this year, but before. Love letters. Buyers want to find some way to relate to sellers, and sellers really kind of like it. And often they'll choose a letter, a response from the buyer. But the National Association of Realtors has made us aware that many times there are fair housing violations. And if it's a fair housing violation, that's going to be a terribly expensive violation for you as an agent and or the buyer. But these letters that buyers often write to try to relate to the seller, if they do include a fair housing violation, there's financial consequences. So we as realtors are not going to be participating in the transfer of those letters. All right. So you just want to make the buyer aware right up front and make them aware of why you're not going to, is because you can't be the judge as to whether or not it's a fair housing violation. And you are not going to put yourself in the middle of it. So just make sure that they understand that you're going to abide by the fair housing laws of the land. Okay. You can highlight some of these things. I'm not going to do it today, but just highlight some of these things of the duties that you might want to make them aware of. This right here, the check mark here, when you're first having your consultation with them, you might want to make sure that you have the sample copies of the offer to purchase and the sample copy of the professional services disclosure. I do have one in this packet that I can send you, because you can't give them the actual form because only realtors can use the form. However, you can give them a sample so they know what they're going to sign if they're going to be writing an offer with you. The home warranty, if the firm assists the buyer in obtaining a home warranty, there is a fee offered to the firm by some warranty companies. We do not take that fee. We do not take that fee or give that fee to the agent. So in here, you're going to put an NA or a 0. Okay. There is, I don't know of any additional provisions usually on a buyer's agency, unless the person might be moving here and they don't know for sure if they're getting the job. But if they're not getting the job, then they're not going to be able to get the loan and buy it. But you may want, if the buyer feels better, you could make some comment in this little section right here that for whatever reason, if they don't get the job, the agreement is void. Can you excuse me just 1 minute? I need to turn off something. I'm sorry, I had phone across the room and my timer was going off to tell me it's 5:02. I should be giving you all a break, but I'm not going to because we got too much to cover. Okay. So hang in there. If you have to be excused, come back. Okay. Now this explanation right here is the more detailed explanation of dual agency. You know, we just touched on it in the disclosure. If they want something in minute detail, this form was redesigned this year. So we do have, I think it's simplified. I feel like it's a good explanation now. And you are welcome to highlight some things on this agency agreement, but at least talk to them again about dual agency and how dual agency works, where you can be an individual dual agent. We don't necessarily recommend it, but you can legally be an individual dual agent. But most of the time when you're representing one party, you're going to either have a designated agency to represent the other party, or you're not, or actually we can have somebody outside the firm. But if it's within the firm, it's dual agency. Again, that itemizes it, clarifies it with, I think, a lot of clarity. Now, this is the new format in our buyer agency agreement. The form writers, again, are trying to help people have a better grasp of what dual agency is. And consequently, they have put this section with an or out here, or it's this section. Now, if they will allow dual agency for the firm, then the next decision would be, would they authorize the individual agent to be a dual agent? It's the firm first, then they would need to authorize you as an individual or not. And if they do not, then they might choose to have someone else designated to represent them. Then if that doesn't work for your client, then what they're most likely saying would be this, or they want exclusive representation by the firm in all transactions. This is exclusive representation by the firm, and of course you, in the whole time of this agreement. We rarely ever see this as long as the agent can explain and help them to understand the value of the designated dual agent. But again, this is a right that the buyer has. Dual agency compensation. If the firm does represent as a dual agent, whether you are the individual dual agent or the firm has a designated, there is going to be the total amount agreed to by the seller that would be paid as the dual agent. You are not going to know that amount because obviously each scenario is going to be different. But the main thing is you want to make them aware that the fee is not going to be less because you do or don't allow dual agency. Okay. Now, this is a new section as well. It talks about termination or breach of contract. In other words, if they go write an offer with another buyer's agent, would be breach of contract. There would be mediation offered and attorney's fees, and who's going to be paying them. These are remedies here. Hopefully that's not going to be a big issue when you're just going into your contract. Now, here you want to make sure that you talk about wire fraud. Wire fraud is still a reality. There's still billions of dollars being taken out of our country in wire fraud. I just saw this morning and I just got so excited. They actually got somebody in jail for wire fraud, but they only put him in jail for 11 years. And I'm thinking, yeah, he'll probably find a way to do it from prison. But anyway, he got caught on wire fraud. So it showed he was in prison. So that's the only one I've seen actually publicized that he got caught. Now this page is a page for information. You definitely want to put all the information on the buyer side here. When we get to the offer to purchase, I don't want you to put the buyer's information on the off the purchase information sheet. But on the buyer's agency agreement, we do need the information, the mailing address, the email address, cell phone number, all the information you can obtain, because sometimes we have to track them down for different reasons. And so you want to have this filled out as much as you, as much as it was asked for, you want to get it filled out. Now, again, if it's an LLC, this is the LLC, the entity, the name of the entity here. This is this is going to be a signature line. This is the name of the person. I think I said his name was John Smith a while ago. So if you have your LLC name here and signature here by John Smith, and the contact information for him as well, and a mailing address. Don't forget the title right here. If it's an LLC, it's going to be the manager, like I mentioned. If it's a trust, it's going to be the trustee. If it's a corporation, it's typically the president. It could possibly be a treasurer, but don't forget that section right there on the title. Now, the bottom section of this, again, is going to be the firm, which is Keller Williams Ballantyne area. Our license number is capital C 13291. Capital C 13291. The firm telephone number is 704-887-6600. Then you're going to have your individual agent signature, see that here, your license number here, and then you want to put your phone number, fax, just put in a, because nobody's doing faxes anymore, and email. Okay, and that would be your information. So now you have a buyer's agency agreement with somebody to buy something in Mecklenburg County and surrounding counties, remember? Okay, here's your offer to purchase sample form. Now, this is what, again, you want to provide up front to the buyer, so the buyer can at least read through it and know what form they're going to be signing when you do write an offer. I'm going to scooch on down through here, and I don't think I put anything else in here for you other than these two sample forms. Every now and then I find some interesting things for you, and I don't think I put it. There's your sample professional services. This is a form that our office requires that you to have with all buyers. It basically is giving you the authority to order things for them or not. And so you want to be familiar with this professional services disclosure form, and you definitely want to make your buyer aware of it. And let me show you a couple of things you want to point out to them early on is the attorney. You're going to have to know who's going to be the escrow agent. Okay, and the escrow agent typically is the closing attorney. The buyer has the right to choose the closing attorney. So you want to talk to them at this point about, do they know of a closing attorney? Have they had one recommended to them? Do they need you to recommend a closing attorney? Have a list of, 2 or 3 closing attorneys that you've worked with and you found them to be efficient and trustworthy. Or they may be attorneys that other agents in the office have recommended. If you're new and you haven't, you don't have your list together, you'll choose some people to go on that list of other agents that would recommend them. And of course, we highly recommend McNaught and Clemens because they're convenient and they are very good because they're right down the hall, and they do support in so many ways. But you don't want to recommend someone unless you personally use them, and you could say, well, I've personally used these, but I have recommendations on the others. Okay, the other thing is this title. The attorney does the title work, but there is something called title insurance. And title insurance is something that we, as a firm, have a joint venture with and have ownership. So we have to have a disclosure form on title insurance. So you might want, that's why I wanted you to take a look at this form early on, because you're going to now come back with a disclosure form for them to sign as you do the offer to purchase, and you want to acclimate them to the term title insurance. Okay. All right. Now let's go over here to this other section of forms that we have. This is for the North Carolina buyers. Now we do have several checklists. We have the checklist that's on DocuSign or in DocuSign, which is very handy. Some people like to have a paper copy that you can print out and have to look at as you go in. You're not necessarily doing it all online. Others of us like doing everything online. This is a buyer's checklist that's it. You can access it in KWB resources. That's our website. You can access the checklist in there if you want to use it. I'm not going to go over it. Obviously, it's self-explanatory. Here's that title insurance selection form. When you do turn the offer to purchase over to the attorney, we need to know, or the attorney's going to need to know, is there a choice of title insurance? And if they will agree to use our Heritage Title, then obviously there is a selection right down here for them to select. And this is a form that you would have to give to the attorney. So the attorney has that we disclosed it to them and they have made a choice. Title insurance is something that all lenders require. And the lenders will also have an attorney, the title insurance to recommend to you, the attorney. One of the things that I like about the fact of having the Heritage Title is that they are making us aware that as owners who might be putting a lot of money into a house, owners need to have their own policy. Lenders are going to require a lender's policy. But if a person is buying a $400,000 house and putting $100,000 down, that's a lot of money that's not insured if there is a problem with the title. So the Heritage Title has made us aware that those owners need their own coverage. So I'm just alerting you to learn more about title insurance. Not that you need to be an expert. They need to call the attorney about that, but just be aware if somebody's going to put a large amount of money that they need an owner's policy to cover that amount of money. Or if they're paying cash. A lot of people are paying cash these days. And if they buy a $400,000 house cash and have enough, so help me, not too long ago, we were looking at a scenario where someone had paid over $700,000 for that property. They custom built the home. They only had title insurance on the lot, which was like $120,000. So they have all the, if there had been a title issue, which there wasn't, but had they been, all that money that they had spent on that custom built home, there was no title insurance on. Is that not, that scared me when I looked at it, went, oh my gosh. So anyway, I spent too much time on that. This is our disclosure that basically lets the buyers know that title insurance is regulated in North Carolina, and it is. There's also in this we have Keller Mortgage, we have Keller Covered, which is insurance. Then this is the form that you need to be disclosing to the buyers that we have these services. It's a disclosure form. The residential property disclosure. Before you write an offer for a buyer, do everything you can to make sure you get the residential property disclosure and the mineral oil and gas. Get those disclosures from the listing firm. It's very important that those disclosures are put in the hands of the buyer before they write the offer. Because look right here, the buyer has basically a 3-day right of rescission. So you want to make sure, see right in here, this explains it. If for whatever reason that buyer does not have that residential property disclosure when they write the offer, they have 3 days from the time they get that residential property disclosure or if 3 days after the effective date happens first, that they can terminate, no questions asked. No, and they get their due diligence back too, if they've already paid that. So I've been in business 40 years. I've been in business this area over 20 years. I've only had 2 cases of this that this has happened. I guess it's happened in other ways, but it doesn't happen often. But someone who really wants to get out of the contract and not lose their due diligence fee, that's the way they do it. So you want to make sure that you get that residential property disclosure in their hands when you are writing it. One of the nicest things that MLS has done, or I've seen in MLS in a long time, is the ability to attach this as an attachment in your MLS listing. So check your listings before you show the properties and make sure to see if it has the residential property and the MOG. Okay. Again, this right here is really important too. If you're assisted in the sale of the property by a licensed real estate broker, you are still responsible for completing and delivering the disclosure statement to the buyers. This is the statement to the seller because the seller does this disclosure. But look here, the broker, the listing agent, must disclose any material facts about the property which he or she knows about or reasonably should know, regardless of this, if the seller tells you or not. All right. So anything that there might be some reasonable knowledge of a listing agent should be telling you, your buyer has a right to know. But you start with getting the disclosure and then you work from there. And when you get it, if you print it off of the MLS, you want to have the owner's signature should be on here, the property address should be here, and then your buyer is going to sign that they got it. It's not that they agree or they've checked anything out. This is basically that they have received it, which then circumvents a right to terminate because they didn't get it. Okay. Right here on the property address, please make sure that it has the property address that you're writing the offer on. I don't know why our agents miss this so much, but make sure that it is on the property address that you're writing it on. I'm not going to go through this. We spent a good bit of time on this last week, and if you want that recording, let me know and I'll send it to you. But I'm not going to go through all these. Just know that you got to have that residential property disclosure. You need to have this MOG. You need to have that because look at that word, mandatory. And I've told you in all these years, I've never seen the word mandatory in a form name until this. So you make sure that you've got those 2 forms in North Carolina. Okay. Right here is the pattern. And this no representation only applies to this. It does not apply to this section. This only applies to that. You still need the answers here and your buyer initials here. This is the seller's disclosure and your buyer's initials. Okay, now here's your offer to purchase. Let's see, we're going to hit the highlights of it. The offer to purchase has not changed substantially. There have been 2 or 3 things that have been added or rearranged this year in this particular one. Again, like we did with the buyer's agency agreement, we're going to put the buyer's name here, and the attorneys really appreciate when you do the legal names. You don't have to, but the attorneys appreciate that. But you're going to have the seller's name. Where are you going to get the seller's name?
Tax records.
Good job. Good job, tax records. Where else might you get it? Looky here.
The MLS.
Look right there. Those disclosures. The seller's names are supposed to be on the disclosures. Okay. So you can look, because that's the same pattern on the residential property disclosure as well as the MOG. So you can get the seller's names there as well. So those are 2 places. And when you're writing your offer, make sure you have the tax records. Thanks for mentioning that. You want to print that out. You want to have your disclosures if you can, and have the MLS agreement, not agreement, MLS data sheet. Anytime you're writing, you want to have those documents there because you're going to start verifying some things that might be in the tax records to make sure they're the same that you saw in MLS. All right. In MLS, you rarely see the seller's names. We don't put them in there. We put them withheld. But that's why you have to go to the tax records. Good job, Jonathan. Okay, so you got to get the seller's name. You've got your buyer's name. This is where you're going to have the information right here that you're verifying. Is the information in the tax records saying the same thing as an address as the MLS? There will be a few times that you'll see a difference there, and it's primarily because of this, the mail delivery. Like I think Weddington, North Carolina is Matthews 28104. So you're going to see an address in Weddington that would say Matthews 28104 because of the mail delivery. So just note there could be a difference in there. And if you see a difference, question it. Okay, just question it because obviously you want to write it on the right property. Your legal description, we do not use plat references in our area of North Carolina. There are other areas that do. So when you're looking at this section right here, when you look at your tax records, you're not going to see references to plat. You are not going to see a plat book or slide or page. You will see a deed reference in the tax records and in the MLS data sheet. You will see a deed reference. The deed reference is going to be a string of numbers, 8 or 9 or 10 numbers with a hyphen somewhere in the middle or somewhere in there. So you'll have the first set of numbers is going to be the book. The second set of numbers after the hyphen is going to be your page number. That's where the deed is recorded. Okay. In this little section right here, make sure you put the legal description, the full legal description. Usually it's going to start with an L, which is a lot. Be able to say L14, M17, B. No, it's usually B and then an M. But whatever that legal description is, it should have it in MLS and it should match tax records. If it's a meets and bounds, you remember in pre-licensing where they had those long descriptions, legal descriptions, put meets and bounds, see attached, and attach that paragraph of that long description. Go ahead and put that with your offer. Now, this right here, this is one of the primary sections that we need to focus on right today. You determine the price the buyer is going to offer. That's done. You want to have your CMA. The thing that I want you to be more conscious of is these two lines right here. The due diligence fee. The due diligence fee, again, remember, it's that period of time that they're buying for the right to terminate for any or no reason, and they're paying a fee for that right. When we were first taught about due diligence fees, the form writers said that we might look at a rental amount for that property. Let's say if the property a monthly rental would be $2,100. They're saying if you're going to do a due diligence period, let's say of 3 weeks, 21 days. So if you might want to divide that $2,100 or whatever the amount is by 30 days, then you multiply it by the 21 days, and that's where you would come up with a reasonable amount to offer on due diligence fees. And I've got to tell you that all went out the window the last 2 years. I mean, we have seen the most, gosh, I can't even fathom the amount of money that people were putting in these houses. Sometimes they haven't even seen the house. They would put $100,000 down as due diligence fee to get the bid that was in those multiple offers. So we are beginning to see a little bit more reasonable amounts offered at due diligence fee right now. So, but whatever they do offer as a due diligence fee, the way it is to be transmitted to the seller is critically important. You see right here, the due diligence fee is made payable and delivered to the seller by the effective date in the manner of cash, personal check, official bank check, wire transfer, or electronic transfer. That's what's been added. The electronic transfer is Venmo, Zelle, PayPal, whatever means that you use or your buyer uses. If they want to use that means, they must check to make sure that they can transmit the amount of money they are offering. These electronic means have maximum daily amounts. So if the buyer's offering $20,000, it isn't going to go to the seller through Zelle or Venmo or any of the ones that I've come across. That would have to be wired. So if it's wired, you are going to need to put your buyer in touch with the attorney verbally to find out how to wire it to that attorney. So the critical thing that they added to this particular offer to purchase has to do with the electronic transfer. Look on the top of the next page. Gives you a little warning about it right here. If the buyer offers to deliver money by an electronic means, bless you, then the seller, if the seller signs this in agreement, the seller must provide that means. In other words, they must have if it's going to go Venmo, they must have a Venmo account. All right. Or if they're going to receive Zelle, they must have a Zelle account. So just make sure that the seller and the listing agent understand that how you're going to transfer it, that they have the means to accept it. And if there's any cost associated with transferring that money, which I think with PayPal there often is, you want to make sure that the buyer knows that they pay those costs, but the seller must facilitate it being done if they sign this agreement. All right. So that's kind of what it explains right here and in this paragraph. Now back up here, the service that they're going to use needs to be identified here. If they're going to do the wire transfer, if it's over $5,000, they're going to most likely, they are going to have to go with wire transfer. And you remind them of the wire fraud warning that information about wiring must be done verbally between the buyer and someone that they know is representing that attorney, the paralegal at the attorney's office. Now, the next thing here is initial earnest money. The initial earnest money is due right here within 5 days of the effective date. Well, what's the effective date? If you go on page 2, you're going to see a lot of definitions. One of the definitions is the effective date. You can verbally tell them, but you want to point it out to them. Right here, it specifies what is the effective date, and that's the date that the last one of the buyer or the seller signs and initials any changes on the on the contract, and it is communicated to the other party. In North Carolina, that is important. As the signature, it's the communication of it. So you don't want to get it signed at 11 o'clock on Saturday night and not communicate it to the other agent until 10 o'clock on Sunday morning. As soon as you get it communicated so that there's no chance of confusion in there. Now let's go back up here to the effective date is let's say you did say at 10 o'clock at night, it became the effective date and you transferred it, and agents are going to say, well, there's no way we can get the money to them at 10 o'clock on Saturday night. That's true. The contract does not allow you an extra period, a grace period of time, but at the same token, there is some reasonableness in there too, that you want to get it to them within the day, let's say within 24 hours, that make sure that the seller does have that check. And what we've found is if you send it a check, if you send it in a way that it can be tracked, you get that tracking number to the seller or the listing agent, and that suffices for getting the check to them within the effective date. Get the tracking number, whether or not you have to send it FedEx, or, and boy, has that gotten expensive. My lands, I cannot believe it, how expensive that is. But they're still the most reliable, although sometimes they fail us too. But make sure you get it, even if you send it through the post office, they also have tracking now, and make sure you send it the most secure and the quickest way with that tracking. Now, the initial earnest money, again, it can be paid with cash, personal check, official bank check, wire transfer, or electronic transfer within 5 days. As we just mentioned that. So make sure that the buyer understands that 5 days is critical. Okay, that 5 days is what they mean. So make sure that they understand. Most of these other things are not as applicable in the majority of your contracts. This is simple arithmetic here. If it's $400,000 minus $20,000 minus $20,000, down here you're going to have $360,000 that's due. It has nothing to do with your loan or down payment or buyers bringing cash. It means there's that much cash still from someplace that got to be provided at the closing. Now, right here, if the buyer for some reason fails to get the due diligence and or the earnest money, the listing agent's responsibility is to send something called a demand letter, and it's done with Form 355. That 355 will be sent to you as the buyer's agent to get it to the buyer, demanding that they pay within 24 hours or 1 business day, I think is the way it reads now. If they do not pay during that period of time, the seller would have a right to terminate the contract. Throughout the entire contract, the seller does not have a right to terminate. It's the buyer's right. This is the one place that it gives the seller the right to terminate if they have not been paid the due diligence fee and or the earnest money. Now, having said that, there are some listing agents who have determined that, and sellers sometimes have determined that if the due diligence fee or the earnest money has not been paid, then they're not going to allow inspection, or they're not going to change the status in MLS. Neither one of those work. Do you know they are in breach of contract if they haven't paid the earnest money? But you cannot, what does they say, 2 wrongs don't make a right. You cannot, as a listing agent, deny them the right to inspect the property. That just came out in a query from the legal counsel for the Realtors Association a couple of months ago. So don't think that you can keep a buyer, although they're in breach of contract, that they can't see the house. What you want to do is enact that Form 355 and 352. If you're the listing agent, if you're the buyer's agent, you remind the listing agent that they cannot keep, the seller cannot keep the buyer from, because that would put them in breach of contract. The aspect of not changing it in MLS, that's against MLS rules. So you have 48 hours or 2 business days to change the status in MLS. So listing agents cannot tell you they won't change the status in MLS, because again, they would be in violation of the MLS rules. So there's really not too much leverage as that the seller has with that buyer who has not paid the due diligence fee. And I got to tell you, we have a lot of cases and a lot of situations, a lot more than we should have, of them not paying. Now, they have also reminded us in this offer to purchase, and again, this is one of the things they added. I want to show it to you. it's down at the end of the contract. It's something called remedies. They've added this entire section here so that if the buyer thinks they're going to breach the contract, such as not paying the due diligence or the earnest money, this right here is what you want to point out to them. Same thing with the seller. If this, then there's sellers who are breaching contracts right now because they're not finding the properties that they want to buy, or for whatever reason they change their mind. So, but right here is the attorney's fees. How it does denote that that's part of the remedy of resolving the attorney. If the attorneys do have to be involved in it, in the collection of the earnest money or whatever other fee is, it they under the parties understand that that would be an indebtedness that would have to be paid. Now let's go back up here to the due diligence. I want to show you one section. Whoops, I went too far. Hold on a minute. Okay, where did he go? There it is. On here, you're going to want to make sure that you talk to them about the earnest money. If for whatever reason they do not pay the due diligence fee and they go past the end of the due diligence period, there is an indebtedness of the earnest money as well. So for someone to say, well, I'm just not going to pay the due diligence fee. I changed my mind. I'm not going to buy the house. The leverage in there is to get something resolved before it goes to the end of the due diligence period, because at that particular time, they then have lost the earnest money. So point that out to a buyer if you have one that thinks that they can get by without paying it. Now look at this due diligence fee right here. A negotiated amount, if any, and if your seller accepts no due diligence fee, then that would be the if any. The if any doesn't count if it's not paid, okay? That's paid by the buyer to the seller with this contract for buyer's right to terminate the contract for any or no reason during the due diligence period. That's what the due diligence fee is. It shall be the property of the seller upon the effective date. It shall be a credit to the buyer at closing. The due diligence fee shall be non-refundable except in the event of a material breach of this contract by the seller, such as the seller not coming to closing, or if this contract is terminated under paragraph 23. I just showed you paragraph 23, or otherwise provided in any addendum here too. The buyer and the seller each expressly waive any right that they may have to deny the right to conduct due diligence or to assert any defense as to the enforceability of this contract based on the absence or the alleged insufficiency of any due diligence fee. That's what I just explained to you. They have the right. The buyer still can do their inspections. It shall be the intent of the parties to create a legally binding contract for the purchase and sale of the property without regard to the existence or the amount of the due diligence fee. You know, I mean, it's like you just by the time you think you got them, you don't. Okay, now here's your due diligence period. You want to make sure that you put a date in here. This was another thing that people during the due diligence, during this period of time of multiple offers, they would shorten the period of time for the due diligence period, basically to say, I'm not going to do an inspection. I am going to give you the due diligence fee. I'm not going to rely on the due diligence period and what I find out during the due diligence fee. I want this house. I'm going to buy this house. That's a scary thing, because even if the buyer elects not to use any of the information that he's gained to choose not to buy the house, he still needs to know what he's buying and needs to know and have that right for any or no reason to not purchase the house, to terminate the contract is what I was trying to think of. And remember, this has to be done by 5 p.m. And you see that thing right there? It says time being of the essence. That means they're serious. That there's no delay on this. There's no grace period. There's no, oh, you meant to get it in here, didn't you? No, at 5 p.m., buyer's agents, you need to make sure that if your buyer does not have an agreed due diligence request signed, something in writing saying what the buyer, or excuse me, what the seller is going to do. If you don't have that, then you suggest to the buyer they have the right to terminate for any or no reason. If they go past that 5 p.m. date, they have lost that right for any reason. Therefore, you must get the termination notice to the listing agent by 5 p.m. Now, just clarify this a little bit. If you, as the buyer's agent, can document the time that it's sent, which typically it's being sent from your forms program or an email, which would be time stamped, it has to be sent prior to 5 p.m. The listing agent does not have to have proof that they received it by 5 p.m. You as the buyer agent just have to have proof that you sent it. And like some of you may have heard me say, it's 5 o'clock somewhere. It's got to be 5 o'clock in North Carolina. It doesn't matter if the buyer is in California and they say, well, I got it to you by 5 o'clock in California. Well, it's 8 o'clock here, or is it the other way around? Whatever. Make sure you get it done by 5 p.m. So it's so that you don't have any argument over on that. All right. Now the next thing would be your settlement date. This is the date that you're going to go to closing. There I did it again. You're going to go to settlement. You're only going to the attorney's office on this date. This is the date lenders aim for. They don't typically have it done early, all right? But hopefully they will have it done by this date, because that's the date all the loan papers are going to be signed. Now, this explains right here what I explained to you earlier. There's 4 things that have to be done. This is what explains it right here before it's considered closed, okay? And primarily it's the recording of the deed, and you let the attorneys handle the rest. Right here, the warning is warning the buyers that they have the right and should select an attorney to represent them and not a title company from another state to close. Now, this little statement, this little section here on special assessments, this is something new. In the past year, special assessments have become a thorn in our sides because we have so many HOAs now. For years, HOAs were only with condominiums, but there's hardly a house out there that is selling now that is not a neighborhood that has an HOA. So special assessments have become a real big issue, and the form writers want to make sure that buyers know there can be and special assessments. If there are special assessment, it's up to the buyer's due diligence to reveal that. And guess who they're going to look to? They're going to look to you to help them to know if there's a special assessment. And the good news to the buyer is, if there is a special assessment, the seller is required to pay it at closing. So that's the good news for the buyer. But what needs to be revealed to the buyer is if an expense is being talked about with an HOA and they haven't voted on it yet, it's not actually a special assessment. It's something that could be assessed in time. The buyer needs to know that. Recently, we had a situation where there were some insurance issues with an HOA. They didn't have the insurance went up so significantly on that condominium complex that they were going to have to add a 40% increase in the HOA dues just to take care of the insurance. So if someone buys something today, as an agent, we are responsible to know that from the seller, and heaven only knows how you're going to be able to find it out if the listing agent doesn't know. But you want to do your dead level best to find out if there's something being discussed that would add an added amount. So somebody buys that place and they 2 months later or a month later, they're all of a sudden assessed 40% higher HOA, which was probably high in the first place. So because it's an older unit, so you want to make sure that your buyer knows if there's something is proposed. We don't use that word anymore, but if there's talk about it. So the seller pays it if it's assessed. If it's not assessed, the buyer will be responsible for it in the future. Okay. Now fixtures is another really big issue. My goodness, you would think with all this list of things, we would have covered just about everything that could possibly be a fixture, and we've named some things that are fixtures that aren't fixtures. Be aware of a storage shed, utility building. Your buyer has a right to that storage shed unless it has been exempted from that sale. There is a place in your MLS data sheet where there is an exemption, and that would be, or an exception, I think is what it's called. If the seller says, I'm not leaving my storage shed, it should be in MLS that they're not leaving it. But if you as a buyer's agent are walking through that property and you see that storage shed, one of the questions is you should be asking that buyer, is that something you like? Is that something you would like to have here? Or you're the contract says that the seller is to leave it. I just wanted to find out, you know, what your feeling of it is, because you need to find out if that's one reason they're buying the house. There are a lot of people love those she sheds. So you want to make sure that the storage building, that's another thing. One of the things to be very conscious of. Another thing would be the alarm and security systems. There are alarms now that have accessories. The security system might have an accessory that doesn't stay with the alarm. That doesn't stay with the security system. The system is built in the house, but you want to make sure that there's not some accessories that are going to go away when that seller goes away. All right. So be sure and check out things about the security system. Don't be caught off guard on that. One of the things that they added a couple of years ago was this paragraph right here: unpairing and deleting data from any devices. One simple thing would be, you know, in cars that have the little that you can program in the car to open the garage door. I mean, that's been around for years. It's not just simple recent, like they have ones now that you can do it on your phone, but those things have to be deleted or they have to be unpaired so that there's no way of having access back into that house, security measures. So just be aware of that. Right here is the area that if there is, let's say, a storage shed, and it is in MLS that it's not going to be conveyed, but let's say your buyer decides they want it anyway, then you would want to go ahead and list that as one that you do want. The thing I'm most concerned with you is this one right here, this paragraph of personal property. Personal property is going to be about anything that's not on that other list, okay? The things that you see most in that paragraph right there is a refrigerator, washer, and dryer. Those are the things that a lender will allow to be included at no value, is a refrigerator, washer, and dryer. And if I ever see one of you all write all appliances in there, I'm going to smack you. All doesn't say diddly. All, it's nondescript. You think you know in your mind that says all. Recently we had a scenario where an agent wrote all appliances, and in his mind he thought it was easier to write all appliances. All appliances is 2 words. Refrigerator, washer, and dryer is 3 words. So he saved himself writing 1 word and has caused untold aggravation and expense because he didn't do his job. Agents, be specific. If you want washer and dryer, put washer and dryer. Do not ever write all appliances. All right. If you want, if your buyer wants the antique bedroom set or the the entertainment area that's maybe about down on the patio. There are several things that could be considered personal things that you think could be included, because the seller has said, well, I'll leave my pool table. Don't put that on the contract. The contract, the lenders, the underwriters are going to knock that out. They're going to have you redo things. So just go into it as a buyer agent, writing what could possibly be accepted. And it, like a pool table or patio set or antique bedroom set, have the buyer or seller do that independent of the real estate contract. It has nothing to do with your real estate contract. Have them do it just like they were selling on Marketplace or Craigslist or something like that. Let the buyer and seller do that independently. And again, don't you ever write all appliances, okay? The due diligence period, we've talked about that at length. So I think you've got that warning down pat already. These are the things that, again, the buyer would be doing. Remember, that's phase 2 I showed you a while ago. This is another itemized list of things for the buyer to do. This little paragraph right here is, well, I've also re-emphasized over and over, the buyer's right to terminate basically is to be done by 5 p.m. on the end date of the due diligence period. They have it to contract for any or no reason. And to be able to do that, you must deliver that notice. It's form 350 is the form that you would need to use with a resale contract. A resale house, residential is what I'm trying to think of. If it's land, it would be 351. So you have those different termination forms. The buyer's representation, this is where the buyer is going to let the seller know what kind of loan, how much down payment he's anticipating bringing into the transaction. If there is a loan that's an FHA VA, you as the buyer's agent need to pull the form FHA VA addendum. It's an amendatory clause addendum that lenders need with all FHA VA loans. And that is a right that the buyer has, that if the property doesn't appraise, they do get the earnest money back. Even if it's past the due diligence period, they do not get the due diligence fee. The due diligence fee is a fee. It is not considered earnest money. So just be aware of what the FHA VA addendum is for, and make sure that you have that addendum if it's an FHA or VA contract or offer, right? This is not a contingency. It doesn't matter if they get this loan or not, as far as them performing on the contract. If they can't get the loan, it's highly recommended that you know before the end of the due diligence period. Sometimes the buyer has to take a chance, but he must be in touch with that lender, and you be in touch with that lender to the best of the lender's ability to convey to you whether or not that buyer is going to be able to buy the property or not. You know, getting the appraisal. Sometimes they don't get the appraisal back, but then the buyer has a decision to make. Do they risk the earnest money by going past the end of due diligence, or do they take the safe route, terminate it, and hope they can get another house? Okay, so there's some real decisions, but just know this is not a contingency of the contract. In our contract, we don't have contingencies. We have a due diligence period and an end date to that due diligence period is the time of the essence. All right. Right here is something else that often buyers from other areas of the country, they're used to, if they can't sell their house someplace else, they're used to being able to get out of the contract here. We do not have a contingency for selling a property in some other part of the country or across the streets for that matter. Selling their property is irrelevant to this contract unless it's done during the due diligence period. Then the buyer would have the confidence that they don't need to have that contingency in there. If your buyer is just really dead set on not being responsible for that contract, if they can't sell their other house, you need to contact the closing attorney or an attorney to draft a contingent sale addendum. We no longer in North Carolina have a contingent sale addendum. We had it for years and years, and every year it would change. And finally, the form writers threw up their hands and they said, we cannot find a way that protects the buyers efficiently. And so they put it back in our laps and said, gee, thanks. Put it back in within the due diligence period. And so if you're going to have a contingency on a sale of another house, you're going to have a longer period of time, particularly now as our market is shifting. You're going to need a longer period of time in your due diligence period, okay? And yes, sometimes that causes that buyer not to get the contract. But just so you know, it's not part of the contract to be able to have the contingency. So, and there are times that a buyer doesn't want to have two payments, but if they can afford and still get the loan, then you could say they don't have to sell another property because they really don't have to sell it according to the lender. All right. So that's one way that if the buyer is willing to take the risk of having two payments for a period of time, then you can you can approach it from that perspective. Otherwise, just have the buyer to know that there's no contingency unless they get a contingency drafted by an attorney. The residential property and owners association disclosure. Remember, I told you I wanted you to print those out from the MLS and have them when you're writing your contract, because you want your buyer to sign those at the same time they'd sign the offer to purchase, that they got it. Right here are some options. This says the buyer has received a signed copy, because you're going to give it to them from MLS. This says they have not received it because you didn't get it. You weren't able to get it to them. This again explains that 3-day right of rescission. Or look here, there's an exemption. Residential property disclosures are exempt in foreclosures, estates, new construction, or family members living in the property. Okay. The fact that an investor has never lived in the property is not a valid exemption. So don't let some investor tell you that. If the fact that they haven't lived in the property, they can check no representation all the way down on that residential property disclosure, but they can't deny giving at least that to you. All right. So be cautious here. If your buyer has not received it, do not check that they have. The listing agent said, well, I'll get it to you in just a little bit. If you're presenting this offer and you have not gotten it, check you haven't gotten it. And then if you do get it, the date that the buyer signs it is going to be past the date of this offer, so you don't have to go back and change it right now, but just do whatever is truthful at the time. Same thing on your mineral and oil and gas disclosure. These are also exempt, with one exemption of the exemption. Mineral, oil and gas rights disclosure does have to be given in the new construction, whereas the residential property disclosure doesn't. You see in the residential property disclosure, there's two things here: residential property and owners association. If for whatever reason the property is exempt, let's say they're in foreclosure, so they don't have to do a residential property disclosure. However, there is a property management, there is an HOA in that development, then you're going to need the owners association disclosure. There is a separate owners disclosure statement in your forms program, so you can get the one that's just for owners. So be aware of those two forms. Here, the buyer's obligation, what the buyer has to pay for at closing. We always recommend that you do a net sheet or an estimated net sheet for sellers. I would recommend that you get your buyer to refer back to the estimate sheet that they get from their lender. The lender's going to give them a good estimate, but you also need to point out to them that there will be some expenses that they will incur if they're not going, if they want some help with those expenses. And I'll show you in a minute where you're going to put, they're going to ask the seller to pay some of that. All these other things that you're going through here, you're going to see the answers in your MLS information, such as is there lead-based paint? If the house was older than 1978, remember for pre-licensing, if it's older than 78, there should be one of those disclosures with attached to the MLS sheet also. In MLS, it's going to tell you how long it's been owned. I think this is rather interesting right here. Does not yet own that property. How can they sell something they don't yet own? Typically, that is a relocation sale, and or it might be what's now being referred to as a wholesale transaction, where one person is buying it from the owner, but then they're putting it on MLS to sell to another buyer and close simultaneously. If you want more information on that, you get that scenario, call me, okay? I'm not going to go any further with that. Wanted to point out this because this is something new on this particular version. Fuel tanks. Up until this particular format of the offer to purchase, the seller could sell fuel that was in the fuel tank. He did have to leave enough fuel in the tank for the buyer to have a final walkthrough. The buyer has a right to all these inspections during due diligence, and they can, but they have the right also to a final walkthrough. And if there's a propane tank that supplies gas for the gas logs, the buyer's not going to have the right to inspect and make sure they work if there's no propane, right? So that became such a big issue that now the form writers have declared that the seller no longer has the right to sell their fuel back to the fuel provider. The seller, if there's fuel in that tank that's not used, it stays in the tank. The seller provides the final walkthrough opportunity to the buyer. And when he closes on the house, the fuel belongs to the buyer. That's the main thing you got to remember. All right. The seller no longer has the right to sell or dispose of that fuel. So now they basically eliminated the fuel providers being able to come in and lock the tank, and now the buyer has to go to the fuel provider and get it unlocked and have to use that provider. So it's kind of eliminated a little sticky situation. But make sure if there's one tank, typically it's only once, and occasionally you're going to find two, but just make sure that you check that there is, and make sure if it's owned or leased. In our area, it's very rarely ever owned. It's most often leased. And so you want to put the information of the fuel provider or whoever is supplying the tank, which is normally the fuel provider. Right here, it explains this a little bit further, that if there is one in the sale, make sure that it's defined there. Here's your seller's obligation. The one exception in this contract where the seller could not perform would be if there's something wrong with the title. You know, there every now and then there'll be something wrong with the title. And if the seller cannot convey clear title to the buyer, then the seller gives the due diligence back, they give the earnest money back, they reimburse the buyer for any expenses the buyer has incurred, because they're in breach, but it wasn't them just choosing to breach. It's that they can't sell. All right. Sometimes that happens in estate sales, where for whatever reason, there's a hang up through probate or something where they can't. I could name 3 or 4 of this, but I'm not going to take the time to now. But just be aware that that's the one exception in this our contract, that the seller, it's not, he doesn't really have a right, but it's a situation that sometimes happens, and the contract covers the fact that the seller then owes that money back to the buyer, including reimbursements. Okay. And this is where it says that they have the right to do the inspections, and then they have the right for the final walkthrough. Make sure that you don't know if the listing agent has told the seller, but make sure that you say to the listing agent, now your seller is going to be out by the time our buyer is ready to move in, right? When we go to settlement. There are some people who think they should have 3 days, a week. There are places in our country that they can have a month for the seller to stay in the property after closing, or whatever they call it. I don't know if they call it a settlement or closing. So make sure that the seller understands that your buyer would prefer that they be out when you do the final walkthrough. And so your final walkthrough is typically going to be done the day of closing or the evening before. All right. Now, basically on through here, this right here is where you're going to have the name of the parties that are going to be the new owners. If it's an individual, it's going to want to make sure this is where you really want the legal names and the spelling correct here. Or you can use this term as directed by buyers. Don't just put as directed. You can put as directed by buyers if you do not have the legal names or the spelling of them. And if the buyer needs some closing costs paid for them, sometimes FHA, particularly when they're going to only have 3.5% down, often they use that FHA because they don't have savings that they need. So they finance the cost by having them into the cost or the sale of property, contract price. And they will ask for the seller to pay so much money toward closing. And that's in that paragraph right there. Now, there's a lot of other things to take a look at, obviously, through here, a lot of prorations, risk of loss, delay in closing. This is one thing I want to point it out to you. I mentioned it in our overview a while ago. If for whatever reason you get to that settlement date and the lender's not ready, or there's an issue with the title that hasn't resolved, those are outside influences that cause not to be able to, or not possible to close. Then you have 7 days. That does not include the seller going on a vacation. They had a cruise scheduled, and so therefore they're going to use up those 7 days. That don't work. If it has to do with a provider that causes them not to be possible to close, then they have 7 days. I don't see too many lenders pushing that 7-day, but some of them are aware of it. So when you get close to closing, you be in touch several times a day with the lender, the attorney, and the other agent to make sure that you're closing in on within that the date in the contract. And if not, that all parties are aware that you're going to have to use 1 or 2 or 7 days. Okay. Now, when you're right here, you'll have some of these forms I mentioned to you a while ago, the FHA, VA, that one and the additional signatures, addendums, what you're going to see most. Okay. Additional signatures might be where there's 3 parties buying the house. It may be a couple and maybe a parent or an adult child, where there's 3. And if you have more than 2, which is what is on the contract, then you want to use that additional signatures addendum. It's a very, very handy little form. Please do not draft anything right here. We have a scenario going on right now that somebody wrote in there, buyer to deliver due diligence fee at first showing, because they wrote an offer during coming soon and they hadn't seen it. Guess who didn't pay the due diligence fee? And now the buyer's agent is in serious trouble because they wrote a statement that the buyer didn't honor And so now we've got an issue. So be very cautious about writing anything in here. Make sure that if there is an addendum, for instance, the contingent sale of a buyer's property somewhere else, make sure that you get an attorney to draft it and write it right in here. Now, I'm not going to go through too much of this else because I've now talked 5 minutes over time you allotted me, and I could spend probably 4 or 5 hours on this contract, as you can well imagine. But make sure if it is an entity that you get the signature of the entity, excuse me, the name of the entity and the signature right here, as we talked about in the buyer's agency agreement. If not, it's the buyer and the seller. Sometimes you have to manually add those fields because the auto populated fields sometimes mess you up. If it is an entity, just be mindful of that. And here's your wire fraud warning again. I can't tell you how important it is that you continue reminding agents. You think, well, I told them, tell them again and tell them what you told them, or you're going to tell them again. Okay. That's just critically important. Now, this is the page I want to remind you, do not put the buyer's information here. You do not want this going to the seller, and you don't want this going to the seller, the listing agent. Same thing on the seller side. You do want to fill all this in, and the attorneys say, please fill this in from MLS to the degree you know it on the listing side, because you can get it from the MLS data sheet, of course. Up here, I would put contact buyer agent. That's all I want you to put, contact buyer's agent. You don't want that information because, again, you don't want them to be too readily available to the other. And here's your receipt page where we do want signatures either from the listing agent that they have received the DDF. You prefer it from the listing agent and the seller. Either one is okay. You prefer from both. That the listing agent is not in the middle of it. Make sure you do get it from the seller. And again, you can take an email on this earnest money from the attorney's office, or you can have them sign this. And again, I told you, I just can't stop talking. I got a lot of stuff to tell you. Thank you so much for being with me today. And like I say, when we send these forms over, put your email address in the box, and I'll get it over to you. Loved having you.
Thanks a lot,
And
Sabra.
good to see you, Jonathan. Now, next week, we'll be talking about South Carolina listings. So those of you who are South Carolina listeners, I look forward to seeing you next week. Let me know if you have any questions.
To take the test.
Oh, really?
Yeah, yesterday.
Yeah. You should be getting a white form then for me to sign.
Soon. Very soon.
As soon as you get that, send it on over and I'll get it signed and I'll send you some more information.
Awesome.
Y'all, if y'all have
Thank
any
you.
questions, let me know.
I'm good.
Well,
Thanks a lot. Bye.
Bye, y'all. Thanks for being with me today. Have a good one.